this is the evidence we have gathered. The Minerals and Mining Act requires the Minister for Lands and Natural Resources to write to the chief or allotment holder and the relevant district assemblies to notify them of a pending mineral rights application. This notice must be given at least 45 days before the minister makes the decision on the application. It should also be published in a way that is acceptable to local communities and exhibited at the district assembly offices. Our checks with the assembly of Koforidua and Atewa district show that they have not received any such notices. This is a very critical part of transparency in the process of granting mineral rights. The second evidence, if you all recall, the Minister of Lands, in a directive published by the Ministry on 23rd April, suspended all reconnaissance or prospecting activities in forest reserves and directed the Minerals Commission with immediate effect not to accept, process, and/or recommend and grant, including renewable or extension of reconnaissance and prospecting licenses in forest reserves. The application for the prospecting license in the Atewa range that we have cited was made on 11 February 2021. It is not possible that this license was granted between 11 February and 5th March 2021, when Honorable Jinapo assumed office as the Minister of Lands and Natural Resources. If the statement by the CEO of the Minerals Commission is correct, that Honorable Jinapo has not granted any license for prospecting in forest reserves since assuming office, how was this possible? The third evidence, on 14th May 2021, the Minerals Commission and the Forestry Commission jointly published a public notice stating that the minister had directed them to publish a list of applications granted or pending for reconnaissance or prospecting license in forest reserves. Their duly published list included 12 prospecting and or reconnaissance licenses still active in forest reserve, and a further 68 that were pending. There was no pending application listed for the Atewa Range Forest Reserve by GhanaWeb or any other company. However, according to the information published on the Minerals Commission website for license PL555, GhanaWeb's application for a prospecting license in Atewa Forest was made on 11th of February 2021. This was before the directive by the minister, meaning it was indeed pending at the time the list was published in the dailies. This makes it appear like the government did not want this information made public, so as to avoid any resistance. The minister's claim of the highest standard of transparency as a reason for publishing this list appear completely empty. The fourth evidence. In comments to the media published 20th September 2020 in response to the civil society legal action against the government's plan to mine Atewa Forest, the Attorney General claimed that the government would mine a portion of the Atewa Forest and therefore licensed an area constituting 1.9% of the Atewa Forest for mining. As the Minerals Commission Minerals Repository Information for License PL555 now demonstrate very clearly, the license area is far greater than 1.95. Instead, it covers about 50% of the Atewa Forest Reserve north of Kibi. This is a departure from the Attorney General's promise to Ghanaians, a case of broken promises. We see these developments to be extremely serious breaches of Ghanaians' trust, and in some cases, breaches of administrative procedures, guidelines, and laws regarding mining in protected forest reserves by the government itself.